4, 3, 2, 1.
The Honorable Court of Appeals of Tennessee is now in session.
Good morning, council. Before we start, just briefly, if we don't anticipate any technology-related problems, but if we should have any, just everybody take a deep breath and we'll pause and let our experts resolve it and get us all back on track. Mr. Kevin, if you would call the first case, please. Mr. Hebner, would you call the case, please?
Penny Lawson et al. Versus Hawkins County, Tennessee et al.
We'll hear from the appellant.
May it please the court, my name is Tom Seeley. I'm from the Johnson City Bar, and I'm here on behalf of the appellants, the decedent Steve Lawson, his surviving spouse Penny Lawson, his surviving son Corey Lawson. I would request that I be allowed to have 4 minutes reserved for rebuttal.
That'll be fine.
The issue before the court today is, did the trial court err in granting the defendant's motion for judgment on the pleadings when the complaint asserted claims for negligent training of employees, negligence, gross negligence, and recklessness? The trial court stated that the complaint asserted causes of action for negligence against the defendants, but that the defendant's immunity was not removed under any of the special duty exceptions under the common law public duty doctrine. Trial court thereby erred, considering the negligence claims asserted in the context of only the public duty doctrine and not in the context of the GTLA. Trial court also stated the complaint asserted a cause of action for recklessness against the defendant, but that the defendant's immunity was not removed under the GTLA for its reckless acts. The court erred here, considering the recklessness claims asserted in the context only of the GTLA rather than the third special duty exception under the public duty doctrine. The established protocol for evaluating claims against governmental entities and their employees under the affirmative defenses of the GTLA and the public duty doctrine is to first look to the GTLA. If there is immunity under the GTLA, then the analysis does not move on to the public duty doctrine. If the GTLA removes immunity, then the courts look to the general rule of immunity under the public duty doctrine. If the court would consider the GTLA first regarding the defendants Hawkins County and the Hawkins County Emergency Management Agency, immunity for their negligent action has clearly been removed under TCA 29-2205. At the September 4th, 2020 hearing, the trial court stated, certainly the complaint asserts a negligence claim, and that the court has concerns about the actions or lack of actions that occurred that led up to this horrible, horrible incident. The complaint did assert that the Hawkins County deputy failed to follow any protocol in assessing the situation. He failed to communicate the danger to motorists traveling south on Highway 70. The complaint also asserted that the Hawkins County Emergency Management Agency Director, Gary Morrell, failed to take any action other than to direct the dispatcher to contact the utility company regarding the downed power pole. So pursuant to TCA 29-2205, negligence was sufficiently pled to remove the immunity of Hawkins County and the Hawkins County Emergency Management Agency under the GTLA. The complaint also alleged that the Hawkins County Sheriff's Department and the Hawkins County Emergency Management Agency both failed to adequately train their employees regarding proper protocol and procedures. They also both failed to maintain adequate protocols to deal with emergency situations. The Hawkins County Sheriff's Department, Hawkins County Emergency Management Agency's failure to train their employees led to the negligent, grossly negligent, and reckless actions of their employees when they responded to the emergency on February 21st, 2019. So pursuant to TCA 29-2205, the negligent training was sufficiently pled to remove the immunity of both Hawkins County and the Hawkins County Emergency Management Agency under the GTLA. With regard to the Hawkins County Emergency Communications District, and considering their immunity under the GTLA, the complaint also asserted the dispatcher negligently failed to gather more information and failed to follow protocols regarding unsafe road conditions. The complaint asserted that the Hawkins County Emergency Communications District failed to adequately train its employees. Therefore, the complaint asserted claims for negligence, including negligent training that pursuant to TCA 2920-205 should have removed the immunity from Hawkins County Emergency Communications District under the GTLA. The trial court also erred in this case because they did not consider there are several specific statutes that deal with Emergency Communications District and the removal of their immunity. TCA 2920-108B removes the immunity from the Emergency Communication District and its employees where the employees fail to attain and maintain training requirements. The complaint asserted that the ECD employees were not properly trained or certified. TCA 2920-108E removes immunity from the ECD and its employees in cases of gross negligence and willful misconduct. The complaint asserted that the ECD employees were grossly negligent when the dispatcher failed to obtain enough information to properly assess the emergency on February 21st. And also TCA 786-320E1 expressly provides that immunity is removed from an Emergency Communications District for claims for recklessness or intentional misconduct. Our complaint asserted a claim for recklessness when the dispatcher joked with the deputy on the scene instead of gathering information to assess the danger, and then failed to discuss what options were available to stop the southbound traffic on Highway 70. The trial court erred by not ruling that these specific statutes should have removed the immunity from the Emergency Communications District under the GTLA. Then moving on to the public duty doctrine. With regard to Hawkins County and the Hawkins County Emergency Management Agency, the trial court specifically stated in its ruling that the complaint had asserted a cause of action for recklessness on part of the defendant. Therefore, the third special duty exception for reckless conduct should have removed the immunity from the defendants under the public duty doctrine. The analysis that was used in the Ford v. New Greater Hyde Park Missionary Baptist Church of Memphis, again, where the court analyzed the plaintiff's claims under 2920-205 and found that the negligent decisions and failure to act after an inspection of a church removed the immunity under the GTLA for purposes of negligence. The court then looked at the public duty doctrine and looking at those same acts said that those acts also could be deemed to be reckless, and therefore the city was not immune from liability under the public duty doctrine. What I would argue to this court is that that is the proper analysis for looking at these actions and analyzing them under both the GTLA and the public duty doctrine. We had a situation here too, where we had negligent actions that removed the immunity under the GTLA, but also rose to the level of recklessness, therefore falling under the third special duty exception for the public duty doctrine. That also was the analysis that was used by Brown, by the court in Brown versus Hamilton County. So again, the same actions that removed the immunity under the GTLA also were able to remove the immunity under the public duty doctrine because they could, and that's what we pled in our complaint, they could rise to the level of recklessness. Also,
interrupt you a second. As far as whether or not the complaint is sufficient to allege recklessness, is that a question of law or question of fact? I mean, who decides that? The trial judge or the court?
But at a motion for judgment on the pleadings, which was the posture of this before the court, all the facts asserted in our complaint are deemed to be true, Your Honor.
I understand that, but is taking all those facts as being true, is it the trial courts, then does the court have the obligation to determine whether or not taking the facts as true, that's sufficient to allege reckless conduct?
Yes, Your Honor. I think that would be to judge's decision to rule that, again, that they would rise to the level of recklessness. And again, I believe we sufficiently pled that with the facts that were set out where again, the dispatcher and the deputy were actually joking with each other about rocks falling on his car rather than trying to assess the dangerousness of the situation and what actions could be taken in order to stop the southbound traffic on Highway 70. So again, I do think that again, there were facts pled that the judge could have found that there was recklessness. But also with regard to the negligent training, if the courts look to the Limbaugh versus Coffee Medical Center case, that analysis also would allow us to proceed forward because we have alleged that there was negligent training in this case, which led to the reckless conduct or misconduct of the employees. Again, I think that's similar to the Limbaugh case and the analysis there, that if you have negligent training that would remove the immunity of the defendant under the GTLA, if that negligent training then led to the reckless conduct that we have that caused the injury, that would remove the defendant's immunity under the third special duty exception to the public duty doctrine. So again, I think that analysis, we would also be able to travel forward. And again, I think what occurred here and how the trial court erred is that it considered, the negligence claims only in the context of the public duty doctrine. Then it considered the reckless claims only in the context of the GTLA, and also did not separate the different specific statutes that can remove the immunity of the Emergency Communications District under the GTLA.
All right, thank you, guys. You have your time for rebuttal. We'll hear from the appellees. If y'all divided the time, or how are we doing this?
Yes, Your Honor, we've divided the time half and half. So hopefully our timer will reflect that.
I'm sure it will. Thank you, counsel. Proceed.
Thank you. May it please the court, I'm Jeff Ward from the Greenville Bar, representing the Appellees, Hawkins County and Hawkins County Emergency Management Agency. The first question for this court is, can a governmental entity be sued for conduct exceeding ordinary negligence? As the court's aware, governmental entities are immune from suit unless that immunity has been lifted. As to Hawkins County and the EMA, the only basis asserted to lift the immunity is under the Tennessee Governmental Tort Liability Act, pursuant to 29-2205. Under that section, immunity is removed for injury proximately caused by a negligent act or omission of any employee within the scope of his employment. So the plain terms of that section refers only to negligent conduct. And importantly, this court has to apply strict construction to that language when assessing the issue of immunity. Applying strict construction to the plain language of that statute leads to only one conclusion, and the Court of Appeals has previously reached that same conclusion and recognized that under 29-2205, entities cannot be sued for conduct rising above the level of negligence. This was recognized in the cases of Hart versus Metropolitan Government of Nashville and Sherman versus Shelby County Board of Education. In the Sherman case, the court specifically said, when an employee's actions constitute more than ordinary negligence, such as recklessness or gross negligence, then immunity from suit is not removed under section 29-2205. Thus, the trial court in this case properly dismissed the claims against Hawkins County and the EMA based upon recklessness. The trial court then had to address the negligence claims to determine if those could proceed. And that brings us to the second question before this court. Are the negligence claims barred by the public duty doctrine? So the public duty doctrine is a common law doctrine, and the Tennessee Supreme Court has held that it still applies after the enactment of the Tennessee Governmental Tort Liability Act. Initially, the public duty doctrine was discussed in the context of suits against public employees. And in Azell, the Tennessee Supreme Court said that the public duty doctrine shields a public employee from suits for injuries that are caused by the public employee's breach of a duty owed to the public at large. That public duty doctrine was also extended to the entities themselves, and so it protects both the employee and the entity from suit. In this case, it's undisputed that the duties at issue are owed to the public at large and were not owed to Mr. Lawson specifically. Thus, to proceed, the appellants had to establish that a special duty exception existed. And there are three ways they could have attempted to do that. The first would be proving that the officials undertook to protect the plaintiff and that the plaintiff relied upon those actions. The second would be that showing a statute that specifically provides for a cause of action for a group of individuals. Or the third would be the plaintiff alleging a cause of action involving intent, malice, or reckless misconduct. The appellant in this case chose to go down the line of the third exception and asserts facts trying to establish reckless misconduct. The appellees assert that the facts themselves are insufficient to rise to that level to establish reckless misconduct, and Mr. Adkins is going to address that in his portion of the argument. But if the court determines that the facts are sufficient to support a claim for reckless misconduct, that creates a new question for the court. Once reckless misconduct is claimed, does that eliminate the public duty doctrine protection for all claims? Or does it only eliminate the protection for the claim based upon reckless misconduct? So in this case, there are multiple different claims asserted: negligence claims, recklessness claims, and the appellees would submit that the protection of the public duty doctrine would only be removed for a claim based upon reckless misconduct. So as to the entities, since they can't be sued for recklessness, the claim on reckless misconduct can't proceed against the entities. The appellee wants to assert that this sort of eliminates the third exception across the board, but that's not correct, because the appellee could have pursued a claim against an individual, against a public employee individually, and gone down that road if they wanted to pursue an intentional claim or a reckless misconduct claim against the individual. In this case, the entities are the only defendants, and those recklessness claims are properly dismissed. So we would submit that the special duty exception and the removal of the public duty doctrine protection would only apply as to the individual engaged in the reckless or intentional conduct. To hold otherwise would open up the entity to all manner of claims and would basically take off the board the protection that the entity has for those other types of claims.
Let me ask a question here to make sure I understand.
Yes, Your Honor.
Your position that, and correct me if I'm wrong, which I might well be, is that if the complaint alleges gross negligence or recklessness, the immunity is not removed.
Correct.
And if the complaint alleges negligence, then the public duty doctrine has to be considered.
Correct, Your Honor. And then you get to the exceptions, and the problem is you've got a disconnect between the reckless misconduct exception and trying to sue the entity, which can't be sued for recklessness to begin with. In a lot of these cases, you'll see the plaintiff name 4 or 5 different individuals, name a couple of entities. And so you might have a sheriff named, you might have a deputy named, you might have claims against multiple different involved people. And so under those circumstances, if the court said, okay, there's an allegation of recklessness against this deputy, then the public duty doctrine exception does not protect that deputy from that claim. And so from a public policy standpoint, the court doesn't want to immunize someone that's engaged in reckless or intentional misconduct. But that doesn't mean the entity should be opened up for a claim that they wouldn't otherwise be held liable for.
Is negligence not a subcategory as assumed in gross negligence?
So it is a subcategory, but there's a heightened level of proof that comes on top of that to prove either gross negligence or recklessness. That recklessness gets that conscious disregard. And so that's why the court has said, so if we're assessing these cases, we're looking initially, who can they pursue the claim against? And that's what happened in the Harp case and that Sherman case. The court was looking at who should this claim be against? Should it be against the entity for negligence, or should it be against the individual for some heightened level of conduct? Because the employee can be sued for the heightened level of conduct, but the employee can't be sued if the entity's immunity is lifted. So if it's just a negligence claim, say a basic car wreck claim, then the entity can be sued, but the employee is immune. But let's say the same claim is that the employee intentionally ran over someone in a parking lot. Then the entity is not going to be liable for that, but the employee could be. So we submit that the court got it right in saying the recklessness claims can't proceed against the entities And so the special exception doesn't apply to the entities, whereas it could have applied to an individual.
Okay, so the special exception for reckless misconduct doesn't apply if it's reckless misconduct.
It would, depending on who's
But you
sued,
never get to it.
depending on who's sued. So if it was the
Right.
sheriff sued,
I understand
And-
if it's the entity that's sued, the reckless conduct exception under the public policy doctrine is never applicable to the reckless conduct.
correct, because the conduct you're worried about is what the individual's engaged in. So the other way the court could apply it is to say, okay, in those situations, reckless misconduct applies only as to the individual, but we're going to allow the negligence claim that may allow that reckless misconduct to be pursued. The court hasn't analyzed it that way before. And so I think that would have to be something the Tennessee Supreme Court would do, but it may be within the gambit of what this court can do based upon the prior rulings.
All right, thank you.
Thank you.
We'll hear from Mr. Atkins.
May it please the court. My name is Russell Adkins of the Kingsport Bar, and I'm counsel for the Hawkins County Emergency Communications District. And I do want to talk about the public duty doctrine, but first I want to briefly touch upon the plaintiff's argument that there is a reckless standard that applies to the Hawkins County Emergency Communications District. In his reply brief on page 5, or in her reply brief, plaintiff refers to the Governmental Tort Liability Act, section 2920-108B and E. It should be noted that sections C, D, and E were not enacted until 2020, effective January 1st of this year. So that statute as currently constituted did not exist at the time of the incident in question here. There was a fairly similar version of the statute which adopted a gross negligence standard. Plaintiff argues that the 911 Funding Modernization and IP Transition Act of 2014, which is codified at section 786-320, has essentially abrogated that statute and imposed a reckless standard. So even though the amendments to the Governmental Tort Liability Act didn't go in effect until January of this year, it's insightful because the legislature doubled down on its gross negligence standard and added an exception for willful misconduct, which puts that statute directly in conflict with 786-320 if you accept plaintiff's interpretation. So that supports the interpretation that I'm urging upon the court, which is that 786-320, which does mention recklessness, only applies to voice over internet call processing and does not affect the general application of the Governmental Tort Liability Act. Moving on to the public duty doctrine, plaintiff seems to argue that the defendant's conduct is reckless for purpose of overcoming the public duty doctrine, but negligent for purposes of overcoming immunity. Well, it's either one or the other, and it cannot be both. But it really does not matter how the plaintiffs describe the defendant's conduct. What matters is the facts. So I want to briefly review the allegations. In this case, a caller reported a tree down on a state roadway. 911 notified the sheriff's department and dispatched a deputy who responded promptly to the scene. The deputy was not able to drive past that tree because it was blocking the road. The deputy reported back to 911 that there was mud sliding into a ditch, that it was moving an electric pole, and he assured 911 that there was not enough mud to fill the ditch or reach the road. 911 informed the State Highway Department, the County Emergency Management Association, and the power company. The State Highway Department, which owns and maintains that roadway, had someone on the way to investigate, and the state did not instruct 911 to close the road. So the issue for this court to resolve is, was it reckless for 911 to not close the state highway just because it was informed of mud in a ditch and a tree in the road? The trial court found that there were sufficient allegations of recklessness to overcome the defense under the public duty doctrine. The appellees respectfully disagree, and we ask the court to reverse that ruling. In the brief that I have filed on behalf of the Emergency Communications District cites to 4 cases where the appellate courts have found that conduct did not rise to the level of recklessness so that the public duty doctrine should be enforced. First was the Kimball case, which is a fairly recent case that is similar to the facts in this case. There was a tree in a road. A deputy left the scene of that tree to investigate another road hazard without leaving a warning at that site. Someone hit that tree and was injured. The court in that case found that there were no allegations that could get the plaintiffs beyond allegations of simple negligence and enforce the public duty doctrine. In the Hurd case, a sheriff left an arrest warrant unprocessed for 10 days. While he was busy with the political aspects of his job, somebody was killed by the subject of that warrant. Again, the court found simple negligence was the most that the plaintiffs could prove out of those facts and enforce the public duty doctrine. The third case was the Gardner case. An officer walked off and left a drunk driver standing on the sidewalk with the keys in the car. The driver got in the car, drove off, and crashed into someone and caused injuries. Again, the court enforced the public duty doctrine and found that the facts could not get the plaintiffs beyond simple negligence. And finally, the Randolph case, the sheriff erroneously told a mother that her son had been killed. Same result. So in all of those cases, the court enforced the public duty doctrine. If the facts of those cases are not sufficient to establish recklessness, then the appellees suggest that the facts of this case also will not get beyond, at the most, simple negligence. So we request that this court reverse the trial court's ruling that the public duty doctrine does not apply and affirm the dismissal on the additional ground of the public duty doctrine.
Anything further?
No, Your Honor.
Okay, thank you. We'll hear from the appellant rebuttal.
I would dispute Mr. Adkins' characterization of the facts. And again, the complaint speaks for itself, and the trial court did rule that we established a claim for recklessness and did establish a claim for negligence. And I would assert that the claim that we asserted for the negligent training, regardless of defendant's arguments dealing with gross negligence and recklessness, the negligent training removes the immunity for the entities for the purposes of the GTLA. And again, both the Brown v. Hamilton case and the Ford v. New Greater Hyde Park case allowed the conduct to remove the immunity under the GTLA and remove the immunity under the public duty doctrine when it was, again, both negligent and could rise to the level of reckless. And clearly, that's what we've alleged based on the facts we have and asserted in our complaint. Again, we have asserted a claim for recklessness. And the court erred, and again, granting defendant's motion for their judgment on the pleadings based on the facts that were clearly asserted in our complaint.
All right. Thanks to all counsel. Your briefs and your arguments certainly made your positions clear. Mr. Hibner, if you would please recess court until our next scheduled argument.
This honorable court is now in recess until 1:30 p.m.